Thank you very much for the opportunity to be here today and talk about the Antelope Valley adjudication, which is an adjudication that covers about 1,300 square miles and involves over 75,000 parties. I should note initially, obviously I am in private practice with Best and Krieger. I'm not here on behalf of any client today. The views I'm expressing are my own, based primarily on my several decades now of experience in the Mojave Groundwater Adjudication, Santa Maria Adjudication, and the last 15 years in Antelope Valley. A couple of preliminary observations. As you know, prior to this year, the law of California groundwater was pretty much pump until a judge tells you not to. And generally, the only way to limit pumping in a groundwater basin was to sue everyone, have an adjudication, which is simply litigation that involves everyone who has a claim to water in a groundwater basin, and get a resolution of that case. I think there are two things to keep in mind as I go through my testimony. The first is that one reason adjudications take so long is that there are parties that benefit from the status quo, and that at the end of an adjudication, there will be certainty and management. As Justice Roby indicated, the court will generally have continuing jurisdiction, there'll be a water master, there'll be management. And generally that management has been pretty successful over the past several, probably half century now that we've really had adjudication management in place. But because that means if the basin's in overdraft, the parties are either going to have to reduce pumping or pay more for water. For some parties, it's a better deal, frankly, to pay attorneys to delay that resolution, because although attorneys aren't cheap, water is even less cheap. And often it's cheaper to pay people in my profession to delay things than to get to that resolution. So I think that this body has an opportunity to change that. I don't think that adjudications have to take as long as they do, and I'll talk about that in the context of the case study of the Antelope Valley. The second observation I wanted to make is that nothing will move a case to settlement faster than a trial date. I agree with Justice Roby that mediation is important, and it is important to provide that opportunity, and he did a great service for us in the Antelope Valley case. But ultimately, a water rights holder, knowing that they're going to have to come to court and prove their water rights, especially if they know the basin's in overdraft, especially if they might have some qualms about proving how much water they've been pumping, that motivates people to resolve cases. And that's true in the Antelope Valley case. And that is why I think this legislation is so important and so complementary to the work that you've already done on sustainable groundwater management. Because there is the potential here, frankly, I think, for some folks to wait the 5 or 7 years till the sustainability plan is done. And if that sustainability plan calls for cutbacks in pumping, to file a lawsuit and say, wait a minute, you can't cut back my pumping until you determine my rights and everyone else's rights in the basin. There are some arguments against that. That lawsuit might fail, but even if it's broad, it's going to take several years. If it succeeds, then they've probably not only bought themselves the 5 to 7 years in the planning process, but another 15 to 20 years or however long it takes to resolve that adjudication. And I don't think that's anyone's desire. And I do want to say, just in reference to Justice Roby, that I think had there been a trial date immediately in the Antelope Valley case after our mediation, he would have settled it. He spent 18 months working on this very hard, and he laid the groundwork for what I think will be the settlement. I think that was really the one thing we didn't have, was that short-term trial date that sort of got everyone's heart racing faster and had the urgency to settle. So let me talk about the Antelope Valley. I do think it's representative of a lot of basins that may be adjudicated or sustainably managed in the future, and that it's a large basin and very complex. It really became a productive agricultural area in the early part of the last century, and from the 1920s to the 1950s, the historic record shows a significant increase in groundwater pumping. Just to give an idea of the quantum of pumping, the safe field, Judge Comar determined the safe field of the basin is about 82,300 acre feet per year. In the 1950s, over 400,000 acre-feet of water was being pumped out of the Antelope Valley on an annual basis.
How much?
400,000. So roughly 5 times the safe yield. Or those are the best estimates we have. Obviously, the historic record is what it is, but those seem to be pretty good. And right now it's estimated the current pumping is maybe in the 125,000 acre-foot range. But so as a result of that dramatic increase in pumping from the 20s to the 50s and 60s, groundwater levels started going down very quickly. And in fact, they started going down so rapidly that in the late 40s, the Los Angeles County Board of Supervisors took the extraordinary action of passing an ordinance to limit the drilling of wells in the Antelope Valley because the water levels were dropping so quickly. You may say, well, if they did that, why do we have a problem? Well, because there was such consternation and outcry when they did that they rescinded the ordinance. But of course, that didn't rescind the problem. And so the well levels kept dropping, but they dropped so substantially that it became non-economical to pump. So a lot of the agriculture went away, starting in the 60s and then particularly in the 70s. So by the time the 1980s came around, State Water Project water was available. So that water was coming in. There was a lot less agriculture. And although the basin was in overdraft the entire time, the well level decline was much smaller. Pumping technology had improved. Agriculture came in again, and primarily in the 1990s in the form of 2 very large carrot farming operations. And the water levels began to drop again. And so that's what created the crisis, the critical overdraft situation in the 90s. There was about, prior to my involvement in the case and prior to the litigation, at least 6 or 7 years of discussion between a lot of the farmers out there and the public agencies about how to resolve this issue. You have what's typically the recipe for controversy: agriculture in close proximity to growing urban areas. Palmdale, Lancaster were growing very quickly at that point in time. So you're having rapid urbanization, and that's moving right in next to agriculture, and so that was creating the issue. Those discussions came to an end in 1999 when the 2 carrot operations, which were Bolthouse and Diamond Farming, filed quiet title actions against the public water suppliers. And basically, Justice Robiarty described the priority system. Overlying rights have priorities over appropriative rights. So their claim in the quiet title action was simply that in a time of shortage, they could pump the water they need under the common law overlying right before the municipal agencies could pump water as appropriators. Well, as Justice Roby also indicated, there is really only one way to change that common law right, and that's to claim that you have a prescriptive right, the adverse possession idea, on behalf of public agencies. And so, that's really the argument that's available to a public agency in that situation. And now this dispute could have played out with the parties that were involved. You just had the 2 farming operations and about a half a dozen public agencies at that point. So you had 7, maybe 10 parties. And you might say, well, why not stop there? Why not just resolve it as to that? Because for the public agency, or frankly for the farming interest, if it's only resolved as to 10 parties and you've got thousands of other parties out there pumping, and that is the accurate number, and tens of thousands of overlying property owners who've never pumped, but who have an overlying correlative right to come on the basin anytime they want and start pumping, you have no certainty. And as a public water supplier reliant on a groundwater basin, for decades to come in terms of planning, you need that certainty. And so you're really left with no choice as a public agency but to bring everybody into a case, start an adjudication, and try and resolve the issues so the basin is managed. And you have some level of certainty, win or lose, at least you have a managed water supply. One thing I should add about the Antelope Valley case that makes it even more complex, and Justice Roby alluded to this, is that the United States is present there. In fact, they're the largest property owner in the basin with Edwards Air Force Base. Typically when you sue the United States, and you can't really leave the largest property owner in the basin out, when you sue them, you have to sue them in federal court. However, water law is unusual in so many ways, and this is another one. There is something called the McCarran Amendment, which is a federal law, which allows you to bring the United States into state court in a groundwater, in any kind of water adjudication, so long as it's comprehensive. But that comprehensiveness means you have to bring in every user or every claimant to water in the area. So the United States was joined. They, of course, insisted on the comprehensiveness requirement of McCarran, and so that set the stage for the Antelope Valley case. And so with that, I want to walk through the timeline for a few minutes, the gory nuts and bolts of this case. And I have to admit, since this is the last 15 years of my life, there were times I got a little nauseous looking back at this and thinking of all the time we'd spent on some of these issues.
I glanced through your timeline.
I'll just hit a few high points.
That's
Believe
right.
me, I'm not going to walk through it item by item.
I was hoping that groundwater bill would assist this.
Oh, it will. No, it will. And we're going to I'll hit a few high points from this case, and I think Ms. Morris in the next panel will offer some specific options on things. The complaint was filed in 1999, and the first thing I want to highlight on that is it wasn't filed in Kern County, and it wasn't filed in Los Angeles County, which is where the real property involved here is. That's where all the water is. It was filed in Riverside County, which is a neutral county. That is an option under the Code of Civil Procedure. But you can see it immediately raises an issue. There's some forum shopping going on about where one would want it to be heard. I mean, it's pretty obvious. Potentially you could say if you're a farmer, you'd rather have it heard in Kern County or a more agricultural county, and if you're a public agency, you'd rather have it in an urban area. It definitely needs to be in a place that can handle complex matters with dozens and dozens, if not 100 plus lawyers, often in the technological facilities in this day and age to handle exhibits. So that's a key thing. So the first complaint was filed. There were multiple complaints filed early on, and trial. Actually, a trial did begin in this about 2.5 years after the case started. But so the first issue is venue. We had a judge in Riverside County, or a commissioner. There were a lot of settlement discussions at that point. The parties were optimistic they could resolve it. The trial started, stopped, it was delayed. But eventually, it was clear it wasn't going to settle. At that point, and this is the second issue, who's going to decide it? So you have where are you going to decide these, what the venue will be, and then who. The commissioner had been reassigned, so she could no longer handle the case. So we received another judge who was 170.6. 170.6 is a Code of Civil Procedure section which allows disqualification of a judge that it does not have to be for cause. It's just automatically filed. One of the risks in these cases is that it says per side, but it's unclear what a side is in a groundwater adjudication. And with hundreds of parties, you can see what could happen. In Santa Maria, we went through several judges through at least two or 170.6. So that would be another issue, is to up front try and get those challenges out of the way, or make clear who can challenge and what a side is in these cases. Because without a limit, that can be another delaying tactic. But so we moved from judge to judge. Another judge who had a conflict and had to recuse himself. And so finally, after a mediation where the retired judge, who was actually the judge in the Aaron Brockovich case, Judge Simmons, told all of us, you really need an adjudication in this basin. Los Angeles County Waterworks District 40, which was the client my firm was representing, did file a cross-complaint for adjudication. So that is now nearly 5 years after the initial complaint was filed. So there's 5 years pretty much just figuring out who's going to handle the case and where it's going to go and where it's going to be decided. I think those are things that this body could shorten substantially. So at that point, when the cross-complaint was filed, the Judicial Council was given the case to assign a judge. They assigned Judge Jack Komar from Santa Clara Superior Court. He had handled, and was currently handling at that point, the Santa Maria adjudication. So he was, I guess, the most experienced judge in the state with groundwater adjudications at that point. So he took the case, and he began to manage it. And at that point, we had to bring everyone into the case because it was a cross-complaint for adjudication. This is, there's not been another basin I'm aware of anywhere where there have been so many parties who own land and aren't pumping. And so there were over 70,000 of those unexercised overliers. There were another, would appear to be 3,000 to 4,000 small pumpers out there, and then 100 to a few thousand large pumpers. And so if we had to serve individually all the unexercised overliers, the 70,000 plus, we'd probably still be serving parties, because it's not an easy thing to personally serve, and that's the law requires efforts of personal service. So the service issue would be another thing that this body could look at, because it took, no one had ever used classes in a groundwater adjudication before. It's a legitimate way to do it. There are class actions and lots of things, but groundwater is a little different than a tort lawsuit against an automobile company or something, which is where you'd often see a class action. And so since we were doing it for the first time, it took years to get the class action right. There were a lot of parties that objected to the way it was being done, and that's like hearing after hearing. So it really took 2.5, 3 years to get the classes worked out and the lawyers appointed to represent them and to get everyone in the case. And so finally,
between those that are pumping and those that are not?
Yes.
Grouped together?
Well, they can be together or separate, but I just think that we grouped them. We created a pumper class and a non-pumper class, frankly, so we could provide them notice without having to personally serve all of them. If there's a way to provide that notice, which is crucial, which is a due process issue under the U.S. Constitution to make sure everyone gets proper notice. But if there's a way to provide that notice without having to go through the class process, that would be a huge, huge time saver in these cases. Because as you can see, we're going from really 2006 to the end of 2009 just getting everyone in the case. And so all of a sudden, we're 10 years in the case, and all we have done is figure out the judge is deciding, and where the judge is sitting is going to decide it, the boundaries of the basin. We did have a trial on boundaries at that point to determine who was in it, and then getting them all in the case. And that took a decade. And so I think those are all areas where there can be tweaks in the law that can just make that move a whole lot faster. So finally, in 2010, we got around to the business of figuring out if the basin was an overdraft in the first place, and so there was a trial in front of Judge Komar. Now, if there's no overdraft, then there can't be prescription, and the water rights allocation is going to be different. In this case, he did find there was an overdraft, and so at that point in time, he did send us to Justice Roby for mediation, and that process went on and off for about 18 months. We couldn't quite get it resolved, so then the court started setting trial dates, and things started to move. People had to produce pumping information, but the first pumping information really produced was in May 2013, some 14 years after the original action was filed. So again, when parties knew they had to come into court, offer pumping data, be prepared to back that up, they began to get very, very serious about how we were going to resolve this matter. And then in this past year, we were going to have another phase of trial. We did have a part of that, but again, that was largely stayed due to settlement talks, and the parties have been in very serious settlement talks for most of this year. And I'm actually optimistic that we will resolve a large part of this case through settlement. So in summary, and I'll be glad to take any questions that you have, I don't think adjudications need to take as long as they do, for the reasons I think there are a lot of procedural things that can be done to shorten that 10 years I described of getting everyone in the case and determining the basin boundary. And I do think that will really complement the work on the Sustainable Groundwater Management Act. And I think that if adjudications can be expedited, that eliminates, to some extent, the safety valve of delay, of being able to drag a case out forever in court. And so with that, I do want to thank you for, you read a lot about water law reform in many contexts, and this body is actually doing something about it, the heavy lifting on it, which is much appreciated by all of us who work in the water business. With that, I'll be glad to take any questions that you have.
I'd like you to do me the favor of just articulating those 3 or 4 recommendations on procedurally in those 10-year period that is causing the delay.
Certainly. And I know that some of the panelists behind me will discuss those as well. But I think on venue, at least having the cases designated as complex means it would go towards a certain court. Not suggesting you pick particular courts by any stretch, but as long as the cases are designated complex,
who would
that's
pick?
important. I'm not suggesting that you would. Not suggesting that. So having the cases designated as complex, I think on notice, there'll be some specific recommendations on notice, and I'll leave those to the next panelist. But I think that finding a way to notice everyone without having to do forming a class will be a substantial time saver. I think limiting or making clear what one side is for the purpose of 170.6, the disqualification of judges. I think that would be it's a minor clarification, I think, really in the law, hopefully non-controversial. I think that's another very key point.
How about determination of the boundaries of the basin? Why can't we get a master plan and a handle on that? This is an ignorant question, but I know there's sub-basins and basins, but you would think once you made that determination, we don't have to go back basin by basin and spend years analyzing that again, or not?
You would. I mean, I think in fairness to the engineering, there's still a lot of art and a lot of nuance in groundwater modeling and understanding groundwater. I think you could start with the Department of Water Resources Bulletin 118 boundaries as a default. I mean, and leave it to parties to come in and have to justify why it shouldn't be that.
The basins change is what you're...
Well, and the knowledge changes. I mean, I think, if you think even with the recent satellite technology that I think has just really been developed in the last couple of years that can show groundwater disappearing underneath, would be inconceivable 25 or 30 years ago when they were drawing some of these boundaries, and that's just a sort of tip of the iceberg on the technology that's available. But that being said, there may be tweaks and some modifications to basins, but if you start with the Bulletin 118 boundaries as a starting point, you probably got, I'm really just guessing here, but I would say 75% to 90% of a basin most of the time. And if someone's really got a strong argument area, it should be a sub-area, of course they should come in and make that. But also what we found is, courts tend to be more inclusive than less inclusive. So I think it would make sense to start there. And at least you could start there for service and get the case moving. And then if you get to management or something and the parties can show their areas really function differently, should be managed differently, the court can provide that relief. But I think on the boundary, starting with the 118 boundaries, which we already have, would be a good start.
All right. Thank you. Dennis? Catherine? No questions. Thank you very much.
All right,
appreciate your testimony.